Sorry about that. I had the wrong case number. It's V-10806-13-APP-1. This is an appeal by Virginia Square Condominium Unit Owners Association of a violation notice issued to the Virginia Square Condo Unit Owners Association on March 5th, 2013, regarding the dimensions of a parking space number 248 located on the G2 level of the building at 901 North Monroe Street. It's in site plan number 275 RAH-3.2 zoning district. It's on the premises known as 901 North Monroe Street.
Okay. And in this matter, we don't really have an issue, we don't have a recommendation, but the issue in question is an appeal. I think we just said that. So what we will be doing now, I think we've talked about that before, we have 20 minutes for the applicant to make his case.
Great. Thank you. I'm Wilbert Washington, here for Virginia Square Condominium Unit Owners Association.
What,
oh, you're here from the staff first?
Yeah, I think we will do the staff report. I mean, we've received the packet and reviewed it, but why don't we have the staff speak first?
Let me just give a very brief report.
Oh, actually, I do have a recommendation. It just was lost on my page. The recommendation is to deny the appeal and uphold the issuance of the notice of violation and civil penalty. So that's the case. Why don't you have a seat for a moment, and we'll call you up as soon as we hear from Ms. Cozart.
All right, we received, the zoning office received a complaint from the owner of parking space number 248 that is located on the G2 level of the condominium building at 901 North Monroe Street. And the issue involved the fact that the complainant felt that the parking space was not up to code or up to the approved site plan. In researching the situation, we found that 901 North Monroe Street is a building, a condominium building, approved by site plan number 275 in 1989. And when a site plan is approved, there is a packet of drawings showing what is to be built, as well as a list of conditions. And in this case, we have an approved packet of drawings, which is called a 4.1, which shows that any compact parking spaces should have a width of 7.5 feet. We also have a condition, number 29, which says that the 290 spaces, parking spaces that are to be built with the building, all of these spaces need to comply with the requirements of Section 33 of the Arlington County Zoning Ordinance. In 1989, when the building was built, the zoning ordinance required that compact spaces be 7.5 feet in width. It appears that the parking space number 248 was not built or is not to that dimension today, that it is of a dimension of 6.5 inches rather than the 7.5 feet. And it was the...
Ms. Kosar, what was that again? 6.5
6.5
feet
rather than the 7.5 feet that's required.
I just wanted to clarify because you had said inches and I wanted to clarify that it was feet.
Sorry, let me just read it. The parking space is 6 feet 5 inches as opposed to 7.5 feet, which would be 7 feet 6 inches required by the zoning ordinance. When a complaint is made to the zoning office that a site plan is not in compliance with the approval, or something about the site plan is not in compliance with the condition, an attempt is made to talk to the Unit Owners Association to remedy the situation. In this case, that attempt was made, but at the end of the day, the association decided to appeal the notice of violation that was issued. The notice of violation was to bring the building into conformance, to bring the parking space into conformance. The notice of violation stated that the parking space was not in conformance, And the request was to bring this space into conformance with the site plan, with the zoning ordinance, and with condition number 29 of the site plan. The decision before the board tonight is whether or not the zoning administrator was correct in issuing the notice of violation.
Thank you, Ms. Cozart. Now we'll hear from the applicant, and you are,
I am Wilbert Washington with Chadwick Washington on behalf of,
okay, before you speak, Mr. Washington, can you fill out a speaker slip?
but I'll be glad to
Okay, thank you.
before I go.
Because I have, somebody else has marked the applicant agent box, and so just want to get this clear.
Great. I will make sure we do that. Wilbert Washington, I'll be the counsel. I'll speak first. We're going to divide our 20 minutes. I'm going to take 10. Our engineer, Eric Edison, will speak after me, and then the president of the association, Christina Polchowski, will close.
Well, he's speaking. If you guys would do speaker splits, that would be great.
I'll be sure to submit after we do.
Okay.
This is a case that is an interesting case in as much as we're talking about parking that was established in 1999 or 1998. The space on the left with the motorcycle is Mr. Saperstein's space. Mr. Saperstein purchased his unit and chose his parking space prior to the acquisition of the space next to it, which is slightly larger. Mr. Saperstein purchased space 248 and the space to the left of it as you face the picture on the other side of the pole. So he's got those two spaces next to each other. The Seversons purchased space 247, which is the space on the right that's currently empty. As you can see, both spaces are small. They are spaces that were established, marked, and available for inspection prior to the acquisition of the spaces by the purchasers that acquired those spaces. They are limited common element parking spaces, such that they are exclusive use easement spaces for the respective owners. They go with the units, they go with the valuation of the units, they're the property that they selected, and were sold to them at cost by the developer Ditmar when the property was sold. They are like a balcony. They go with the unit, they are an exclusive use area just like a balcony in a condominium. What we have in this case is a situation where, due to the vagaries of construction, there was a site plan, the building was inspected, certificate of occupancy was issued for the building as it was constructed. And the building was constructed with some spaces that frankly were not conforming with the zoning ordinance. Neither of those, well, in this case, one space, 247 rather, does conform in that it is over 7 feet 5 inches, it is 7 feet 7 inches. The other space, though, is only 6 feet 5 inches, and it is substantially lower than what the ordinance calls for. Staff has recommended that the solution to the problem is to measure from the center of the two poles in order to create two spaces that are 7.5 feet, or 7 feet 6 inches wide. However, everybody knows that you can't park anything through a pole. So the actual usable space, the actual parking space, would really have to be measured between the poles. And if you measure between the poles, it is physically impossible to create spaces that conform with the ordinance. But the suggestion is to measure and use unusable space in order to create the capacity to use that space for parking that conforms with the ordinance. Now, we appreciate that there might be an easy answer, which is just split it, draw it down the middle, and call it a day. But that ignores a number of things. First of all, it ignores the fact that the building was put together, it was inspected, it was approved and certified for occupancy as this was constructed. In 2005, the building was restriped when they put on a membrane on the floor, but pains were taken, as will be discussed later, to make sure that the striping was exactly where it was before. So the striping is now as it was in the beginning when the individuals purchased these spaces. The individuals purchased these spaces have property rights. They own the right to use that space. The association does not have the right nor the authority to take inches away from one and give it to another. They don't have that capacity any more than they have the capacity to walk up to somebody's balcony and say, slide the partition to your neighbor's side to give them a bigger balcony. They don't have that capacity because this is not a general common element, it's a limited exclusive use common element. So there isn't really, at the end of the day, unfortunately, a solution that fits in a box. We can't create two conforming spaces. The solution that is suggested creates a fiction of being able to park in concrete, which obviously isn't appropriate. You can't move the concrete because those are the columns that are holding up a multi-story building, and it would be extremely expensive, as you'll hear testimony on later, to move that. So that's not really a viable solution. It certainly creates an undue hardship on the association or the people using the spaces. So what do you do? What's the appropriate thing to do to be able to have an effective solution here? And we suggest that the answer is you leave it alone. It was approved by the county in the beginning. It was purchased as it is by the owners, and there's no way to make the spaces fit in the ordinance. You cannot make them fit. It's physically impossible. So since you can't make them fit, a solution of making both spaces non-conforming doesn't sound like a reasonable solution. It sounds like an easy solution, but it's not a reasonable nor a lawful solution. Indeed, one might suggest that given that there's no basis for making both spaces non-conforming, that you are effectively engaging in arbitrary and capricious conduct if you were to make that decision with regard to splitting of this baby. I would also suggest to you that in so doing, you would be taking space away from a rightful owner and giving it to another owner, which would be an unconstitutional taking. You would be taking space from 247 to give it to 248 for no real rational basis, because you're still not going to create two conforming spaces. You're just going to make the smaller space bigger. And why would you do that? Because Mr. Saperstein came to the county repeatedly and badgered the county into taking this case on after an extended period of time. For years, the county said this was okay. When the spaces were restriped, as Mr. Saperstein suggested that the striping changed in 2005, there was no complaint lodged by Mr. Saperstein until 2010. If indeed the space was shrunken down in 2005 when it was restriped, one would think, A, he'd have evidence to establish that, and B, that he would have complained about it immediately, not 5 years later. He served on the board, as you will hear. He was in a position of authority. He knew how to get to the people that controlled the space and could have had some influence over it, but he chose to do nothing about it for 5 years. And then he found the county, and he found, in an interesting point, that the ordinance called for larger spaces than he had. And he therefore suggested that there was some kind of violation that needed to be addressed. We say no. There is no violation, in as much as we have a lawful nonconforming use. The building was built, it was built to plan, it was certified, certificate of occupancy was given, and the owners have used that space and paid taxes on that space for about 15 years. And under those circumstances, you have a lawful nonconforming use that you are prohibited from taking action against. Now, the staff has suggested in their report that we're not saying that it's an unlawful use, but you can't issue a violation for a lawful use. So they have issued violations claiming that this use, this allocation of space, was an unlawful use. And we say that by the nature of the way this building was constructed, and as is in our brief is better explained, this is a lawful nonconforming use, and one which you really don't have the authority to address, nor does the zoning administration have the authority to issue zoning violations related to these spaces or the allocation of space in these buildings. At the end of the day, I think it is clear that there is a desire by Mr. Saperstein to have a larger space. He certainly believes that he could hopefully convince you to do the heavy lifting for him to get him a larger space. But he had a chance, if he wanted a larger space, to acquire a larger space when he first bought. He had every opportunity to see what he was buying and to buy something different. When he bought the spaces that he bought before the owner of 247 bought. So he could have bought 247 instead of 248. He could have bought a space someplace else in the garage that was larger, but he chose voluntarily of his own free will to purchase that space. And now he's coming to you 14, 15 years later and saying, you need to make the association move the line for me so that I'll have a bigger space. It still won't be a conforming space. It'll still be too small for that. It will make my neighbors who have a small space that they can barely fit into now have even more difficulty and suffer an undue hardship so that I can have a few more inches. Why would he do that? He doesn't even live there and use that space. He doesn't use that parking space. He rents or hopes to rent that space to generate income. That's all fine and laudable, and in America, everybody's got a right to make money, but they don't have a right to take their neighbor's space in order to improve their property values. And that's what this, in the end of the day, is about. And that is not what zoning is about. That is not what the BZA should be about in terms of affirming a decision that has the net effect of being a land grab for Mr. Saperstein at the cost of the Seversons. Beyond that, from the association standpoint, A, we don't have the authority to do what the county is telling us to do in terms of taking the Severson space and giving it to Saperstein. B, there are other spaces in the property that, because of the configuration of the property, which was inspected and by plan and authorized by the county, built by Ditmar, not by the association, but there are other spaces that are likely subject to similar treatment. which would cause the hardship of the association having to fight these battles repeatedly and or restriping the property at great expense to themselves, and still having to face the issue of not having real authority or lawful authority to take space away from one property owner and give it to another. Under those circumstances, we think that the appropriate thing to do is to grant a variance to the association. And this is the appropriate task because we have all of the corners of a variance in place. It's been like this for 14, 15 years. It's worked fine for that entire time. So it's obvious that it's an appropriate use of the space that would not cause any hardship to anybody by leaving the status quo in place. But if you were to change the spaces, you would cause two non-conforming spaces, and you would cause the Seversons in 247 to have less space than they purchased, lower the property values of their home, and thereby work an undue burden on them. If you were to grant a variance, we would avoid that undue burden. We would avoid the undue burden to the association of restriping multiple places in the property, and there would be zero impact on either of the adjacent spaces. There would also be no impact on the district, and it would be consistent with the intention of the zoning that was applied, and is that the uses would still be the same, and frankly, they would be as they are. So under the circumstances, we believe, and we've requested, that you use your authority to grant a variance to maintain the status quo and leave the spaces as they are, as they were approved by the county, and as they were purchased by the owners in question. I'm now going to turn the floor over to Mr. Edelson to speak to you with regard to the engineering involved here.
Good evening. My name is Eric Edelson. I'm a professional engineer in the state of Virginia. I specialize in forensic analysis and repair and restoration of garages in particular. I've been involved in this garage since the day it became a condominium. I am the engineer that was in responsible charge for the 2005 project when the garage was restriped. I've been asked to certify two things. One, the stripe is in the exact same place it had been from day one. I know that because the way the garage was restriped, it has a waterproof membrane on it. We placed that membrane. You cannot see through the membrane. Therefore, you cannot see where the stripe had been. However, before placing the membrane, duct tape was placed on the wall at the location of the stripe. Then, after the membrane was placed, we had a marker of where the stripe had been. The stripe was then replaced in the exact same location. The other thing is, it would appear a nice idea if you could just make the whole space wider. Well, as you see in the photograph, there's two building columns. They hold up a 12-story building. Can't move those columns. It would be astronomical in expense to try to move those columns. Therefore, they must stay in their current location. Therefore, it's impossible to make the space wider. So in my conclusion, I have done two things. I've kept the space exactly as it had been, and I can tell you that you cannot move the building columns.
Hello, my name is Dr. Christina Pahalski, and I currently serve as the president of the board at the Virginia Square Condominium Association, and I've served on the board in one capacity or another since 1999. As president of the board, I'm virtually involved in all the matters of the condominium, including pertaining to owner's complaint. But also as an owner at the condominium, I am also responsible for the payment of the fines the condominium is facing. I am familiar with this case, very familiar, and I've known Mr. Saperstein for many years. He actually served as chair of our Budget and Finance Committee for many years, and then eventually was on the board himself. He first complained to us about the space issue 5 years after the completion of the project, as you just heard from Mr. Washington. He had never made any mentions of his concerns to any of us, even though he actually worked with us on the board until that time. Once he did tell us of his concerns, we investigated, and we found nothing to substantiate his claims. Mr. Saperstein alleges that his parking space was restriped incorrectly, but I have had firsthand observation of this project during the time that it was going on. I'm aware, that, as you've already heard, that Mr. Edelstein and his contractors took great pains to make sure that the striping was exact. Mr. Saperstein has asked, the county has suggested that the association widen his space by moving the line 3 inches to the right. And as you've heard, we do not, as an association, have the right to infringe on the property rights of the other neighbor, Mr. Severinsen and his wife. It's totally inappropriate for us to take space legally from another resident. And the final point I want to make is, as an owner and also as president of the Virginia Square Condominium, where I represent the other owners, I feel it is personally wrong to impose these fines for alleged zoning violations regarding the size of these two spaces. We did not cause this problem, and we are unable to resolve it in a way that's fair and legal and respectful. And as we've already heard, the county proposes a solution which will make both spaces unusable. You know, as a physician, one of the vows that we take is to first do no harm. And I really honestly believe, deep down inside, that the decision the county has made to date would cause harm. It would cause harm to Mr. Severinsen and his wife in their space, a lot of harm, for a marginal benefit to Mr. Saperstein. And it certainly would cause harm to the association by levying fines for something in which we did not cause. So I respectfully ask that you maintain the status quo, and I appreciate your thoughtful attention to this matter. Thank you.
Yes, if I could have those, Mr. Washington, I'll take them. Thank you. Okay, I'm not sure, and I'm also not sure whether we would want to, at this point, also if we want to take up the next case as well, or do them.
I think that the result of this case affects the next case, so we could do it.
So the next case involves the Severinsons who are intimately related in terms of their case. So I think it might make more sense to call that case now and then have the testimony as part of this as well. We do have several speakers on this case, and I want to get through those as well. But I just thought procedurally, as I look at this case, I think we should call both of them. So, Mr. Noxon.
Okay, the second appeal case is V-10807-13-APP-1. This is an appeal by Lucky and Karen Severson that a violation notice issued to the Virginia Square Condo Unit Owners Association on March 5th, 2013, regarding the dimensions of parking space number 248 located on the G2 level of 901 North Monroe Street. Site plan number 275 would adversely affect their property rights in parking space number 247. It's in the RAH-3.2 zoning district on the premises known as 901 North Monroe Street.
And this, basically, the facts are the same. This is just the owner of the adjacent space. And the Seversons did have some issues about notification and about Mr. Saperstein having waited so long to make the complaint, et cetera, and the fact that we would be infringing on their property rights, if we did anything to the size of the spaces. So it's essentially the same case that I issued a notice of violation, and they don't feel that I had the right to issue that notice.
And the recommendation is to deny the appeal and uphold the issuance of the notice of violation and civil penalty. Now, that notice of violation and civil penalty is not to the applicants themselves, even though the procedural documentation indicates that they are the applicant. They're not the applicant because they're not seeking anything from the zoning administrator. They're seeking remedy and an adjudication of the issue before the Board of Zoning Appeals. And I think that that is appropriately part of the case that we're hearing, and so that issue is what we'll be dealing with in this case. So with both cases now before us, I think we'll proceed to our witnesses.
He's the attorney for
Okay, we actually have an attorney for Ms. Severson, so why don't you have 20 minutes, and that's John, is it Puvak?
Yes, ma'am.
Okay, Mr. Puvak.
Good evening. John Puvak with the law firm of Walsh Colucci on behalf of Mr. and Mrs. Severson. Respectfully, I would like to clarify the distinction between our position and this. They are two separate appeal matters. Mr. and Mrs. Severson did appeal the violation. Although they are not a named party, they felt that it was only prudent to do so to protect their interests as the owner of Space 247. So I do believe that procedurally, we would like a separate action on our item because, as I plan to make in a moment, I think that these issues can be distinguished, although we are aligned with many of the comments that Mr. Washington made from the Condo Board Council, that the untaking, that the change of our space would result in an unconstitutional taking. The distinction is that space 247 simply is conforming. It meets every requirement of the zoning ordinance today. The space 247 is purely implicated in this as a corrective measure. The indication is that 247 should be restriped in some way to allow 248 to be increased in size. To that end, it's an arbitrary and a corrective measure. For example, the space to the left of, page left, if you're looking up there, of 248 could equally be restriped as well and take space from that side. Although there's a column there, again, it is arbitrary because we're ignoring the functionality of these spaces, as Mr. Washington made quite eloquently. To change these spaces limits their functionality. The spaces have been in existence for 15 years, have been used by Mr. and Mrs. Severstein since their time, and Mr. Saperstein for that time. Although they are challenged, although they are small spaces, in fact, they do function today. Further, space 247, as you see, has a column that's placed farther back. As you can imagine, as you can see to the car that's parked to the side, that's directly in front of a passenger side car door. So to reduce that space by any means would further eliminate any opportunity to do so. So I do think that the position of Mr. and Mrs. Severstein can be distinguished. Again, to reiterate, the garage was inspected, a certificate of occupancy was approved, as I think Ms. Cozart would confirm. When a certificate of occupancy is approved, garage inspections are done, spaces are checked, and there's space to be compliant with that. The approved 4.1 drawings did not include a measurement. They simply said a site plan condition that the spaces would comply with the zoning ordinance. Superseded to that was a condo board declaration that specified the number of the spaces. In fact, on that, and it's included in your staff report as one of the exhibits to the zoning administrator's position, that these spaces would be approximate, that the dimensions could vary slightly. I think that's an important distinction, is that that's in the recorded deed that the spaces could vary slightly. So when we're arguing about minor changes of spaces, that's an important distinction. To reiterate, the remedy posed by the zoning administrator is infeasible and truly arbitrary. As I've alluded to before, the space could be restriped, space 249 could be restriped to make the space larger. If all we're worried about is making spaces 7 feet 5 inches, then there's other ways that could be done, not to the detriment of space 247. I'd like to introduce Mrs. Karen Sevenstein to make a few comments, just to explain a little bit her use of the space over the last 14 years since she acquired the property.
Thank you very much. I'm Karen Severson, and my husband and I, Lucky Severson, own the property, which is parking space 247 in Virginia Square condominiums, and you see it there on the screen. We have owned this property for 15 years. We have used it for that long, and during that time, we have never had any problems. It does not violate any zoning ordinance of which we are aware. And as far as, and the size of the space has not been altered from the time that we have owned it. I think that if you will look, our 270 or 247 space has a particular challenge, and I think if you will look at the screen, you will see, John alluded to it, but as you will see, on the passing, when a car is parked in our parking space 247, the large column there is directly next to the passenger side doors. I mean, it isn't, because of the size of the space, it isn't 6 inches away or whatever. It is directly next to it, so it's impossible to enter or exit the passenger side doors when we are parked in our space. So when my husband and I travel together, he backs the car out, and I get in the passenger side, and then we leave. On the driver's side, of course, if there is a car parked in 249, there is barely enough space to get in, but you can accomplish that, just as you can get in the passenger side of 249 when a car is parked there. Now, if you look at 249, you'll see that that column, since it's next to the left rear fender, of the car that would be parked there allows free entry and exit from the driver's side door. So really, I mean, that space is as usable as our space is, even given the current dimensions of the two spaces. If you were to take our property, and make no mistake, that's exactly what we think you are doing, and unlawfully, you would render our parking space unusable. It would be impossible to park there, and it would not be a useful piece of property any longer. So, I mean, I think that we are outraged by that solution. I'm sorry. I apologize. You seem like a very nice person, but we really were flabbergasted by the remedy that was proposed, especially since it does not bring the two parking spaces into compliance. You have now one parking space in compliance and the other one that does not conform. To make the change would simply mean that you would have two parking spaces that did not conform, and that just challenges my logic, I think any reasonable person's idea of what a logical solution might be, or a fair solution, especially since you are taking our property. I mean, that is what you are doing. And not only that, we were never advised or informed by the county that you were conducting any kind of investigation of these parking spaces. We did not know until the board president carried a copy of the decision letter to our condominium that the county was involved in this and that a decision had been made. I mean, a decision was made to take our property. We weren't even CC'd on the letter. That, to me, I can't believe that can happen. I can't believe the county would do that. I honestly can't believe that it could happen in this especially in Arlington County, which I've always held up as a great example of how things are conducted in such a great way. But in this case, I think that you've really let us down. And I really hope you'll reconsider. I'm sorry if it means that the administrator would have to be found to have made the wrong decision. But honestly, I think you did make the wrong decision. And as you can see, this decision, even though it's arbitrary, does have a face and an effect. And I'm the person who is telling you that you've done something that you really should not do. So, thank you very much.
Is that everything you wanted to say, ma'am?
Yeah.
Okay, thank you. Because technically, she should have had the time with the 20 minutes, because, shouldn't she?
That was their time.
Oh, I thought she reset it.
She reset it. But
You got the remainder.
Yeah, but as the applicant, she'd be part of that 20 minutes normally.
She couldn't have 20 more. They don't.
No, but she reset it to 5 for her, from 13. But anyway, we're good. We got it covered.
I'll wrap it up. I would only add that we.
No, not another 20.
I would ask them. I'm going to introduce an affidavit from Ms. Severson that just restates her position, and I would ask that you would overrule the decision of the zoning administrator as she was incorrect, and especially as including 247 as a remedial action, and ask you to overturn her decision. Thank you.
Okay. Any questions of the staff at this point?
I do. Madam Chair, Ms. Cozart, in 1999, I think it was Mr. Pivac who said that certificate of occupancy required an inspection of the parking. Mm-hmm. Was that done in 2005 after the resealing and restriping?
No, because there was no application made to the county as far as a permit to do that. It was just done.
And the do you know whether for example, Ms. Severinson's deed for this parking space contains dimensions?
Yes, as part of your packet, the deed that I understand, the drawing that went with the deeds showed 247 and 248, and it showed dimensions. So both parking spaces,
Well, okay, was that like page 74?
yeah, both parking spaces were shown on the drawing that was included with the deeds.
Okay, I'm looking at, and maybe it's Mr. Washington who can help me with this. Would page 74 of the, it's labeled, it's actually not their page 74, but there's a number 74 on a page that looks like this.
My understanding is the plat attached to the bylaws that reflects.
Attached to the bylaws given to each condo owner when they buy the property, the bylaws have to be passed along, and so it would identify specifically, and this says 7 foot 8 inches and 7 foot 6 inches. But of course, this is as of 1999, I bet, or sometime thereabout, right?
Those numbers would go with the site plan as opposed to the actual as-built.
Come to the mic, perhaps.
Those dimensions are reflective of the site plan. That was what was supposed to have been built by the site plan. That is not what actually was installed by those dimensions.
Except, Mr. Washington, isn't it true that the evidence indicates that 247 is built at 7.6?
247 is actually 7 feet 7 inches. It's conforming. 248 is 6 feet.
More importantly, it's what was reflected on the site plan.
That's correct. It's or closer to it.
And so there are going to be, there's a site plan, and then each individual owner, when they buy the space, or buy the unit and buy spaces, let me ask, at the time of purchase of a condo, can you buy any number of spaces?
Yes. They have 2 spaces, as does the owner of 248.
They could have bought 3 if they wanted to?
If they were willing to spend the money, Ditmar was willing to sell it.
Mm-hmm. And they could pick those spaces based on availability anywhere in the parking structure?
That's correct.
And now I'm getting to what was attached to the bylaws. This?
The bylaws had the plat that reflected the spaces in the garage.
Okay. Can you, is that
That's,
included in here somewhere?
that would be this, wouldn't it?
I don't know if that was attached to the bylaws or not.
We have it in the declaration, and we can certainly submit this to you all for your consideration.
One more.
That includes the plat.
The bad acoustics of this room, coupled with my tinnitus, make it very difficult for me to hear sometimes.
I share your condition. I have the recorded declaration for the condominium, which has the plat attached that reflects the parking spaces, which
Okay.
we are happy to submit.
You have multiple copies of that? I'd like to see what each,
think we
for
only have
example,
one,
Ms. Severinson had in her hand for dimensions, what she relies on.
Right. She had this, which I'll provide, and she had the opportunity to actually physically look at the spaces in question, as did all other owners.
Follow-up question. Does she have this, that we have, this is page 74 he was talking about? And this is from the county board-approved site plan, 4.1?
No, that is an exhibit to the declaration of the bylaws. So,
And you took, or someone took, the county board-approved site plan, which is stamped by Ditmar and everything, and embellished it to include the dimensions and so forth for the...
that's correct.
Is that correct? Because we have the 4.1 right here, and they don't have dimensions written out in the same way, and I just wanted to be clear what I'm looking at here.
Correct, sir.
Thank you.
Thank you, Mr. Russell, also for helping with that. That's all for right now, Madam Chair. I'm sure I'll have some more in just a little while.
Okay, if there's no more questions right now, we'd ask the applicant's representatives to move to the back, or at least move back from the tables, and we'll start our testimony in this.
It is attached exactly to what's filed.
I think,
Page, but I'm sure that's one level. That's the second level.
so Last one. I'm kind of confused on what for and against means in this case, but we'll start with the first speaker, Yuri Skaton? Or
Oh, Madam Chair,
Sakata?
one more thing before you get to that. Mr. Edelson, the affidavit, and Mr. Washington, there's an affidavit that's referred to Mr. Edelson's. Is that in our packet somewhere, his affidavit?
I submitted affidavits, I submitted a brief.
These were a different case.
Can you come forward and actually put that on the record, please?
I had submitted a brief and affidavits from Ms. Polchowski and from Mr. Edelson.
Okay,
I provided 7 copies.
Yeah, that's what I passed you all out.
I have, this is the brief. Point me to an affidavit.
It's probably at the back.
Should have a copy there. Yeah, that's it.
I don't think we're seeing the affidavit, Mr. Noxon.
And I imagine it looks like Ms.
Yes.
Severson's?
Yes,
I don't-
they were clipped together, there were 7 of them. The original was on top.
Give you another one.
This is it. Oh, those are my deferred cases. Oh, there's my notes. That's the brief. The affidavit, though. See, we have that. Oh, we're not, we don't see how to see his affidavit.
But you can go ahead. I mean, I just want to see that, a piece of paper, but you can go ahead and call the witnesses, Madam Chair.
Okay, so the first, thank you, Mr. Washington. First witness, let me get that back again. Okay, yes.
I was just called as a speaker, and I was actually did not register to speak for this case.
You were speaking for this case?
No,
Okay, which case are you supposed to be speaking for? Do you know the name?
the Bartles, 1420 North Utah Street.
Okay, yep, sorry.
Just 6 and 7.
Okay, so 6. So I have 2 speakers. The first is Clifford Kifo, sorry.
Hi. Now, should Mr. Saperstein be speaking before the
He has not put in a speaker slip.
Better.
Oh, he does have a speaker slip. Let's call Mr. Saperstein first.
Okay, thanks.
I'm Mr. Saperstein, the infamous Mr. Saperstein. You've heard about me a lot. I'm glad to hear that we're beginning to talk things about land records and deeds. Most important, we purchased it in 1998. We had 2 cars, and we used both parking spots between 2000.
Which parking spots, Mr.?
248 and 249. 249 is not an issue. We used both parking spots. Between December 2001 and 2004, I personally parked, and many times, hundreds of times, our current car, a Toyota Civic in 248. After the restriping, I noticed that the Seversons had a different car. No longer did they have their compact Toyota Corolla. Now they had a mid-sized Toyota Prius. That shocked me. I tried to park in our spot, 248. No way, it had been changed. I measured it, it had been changed. I went and complained to the manager, and he told me very, very bluntly, if you know what's good for you, you'll shut up, because the board will not back you, will not back you. It's against my religion to go against that. I'm a devout coward. And I value my health. This guy towered over me. So what I had to do, I went to the condominium president. I pleaded with her. She says, well, we'll consider it. And it was put off for years. My mistake. I should have been more forceful before I finally said documentation. Nothing could be done. The condominium board was obviously not going to do anything, so I went to the county board. They agreed with me. They referred it to the county manager and then to the zoning who issued this appeal. Now, the question I have, the most important thing is, I thought when I presented it to the condominium president, I presented the land records, I thought this was it. This is what we purchased. This is America. We don't change land records. All our deeds refer to land records. What would happen if we couldn't rely on deeds and land records? That space was altered. I know it was altered. Please support us. We cannot use that space now, except for a motorcycle, and I don't ride a motorcycle. Thank you.
Any questions? Okay. Let's go. Now we'll have Mr. Kifo.
Hi, it's Cliff Chieffo, and I'm an owner. And I was on the original rules committee that wrote all the parking regulations for the garage, so I'm more or less intimate with the space situation. So I have like 5 bullets for you today, metaphorically speaking. The first, all of the spaces are measured from the center of the column, so there's nothing unusual about this space. Now, the problem occurs when the floor was restriped after repainted at covering the original yellow striping in 2005. There were several subsequent restriping mistakes. It was just simply, frankly, I thought, a rather bad mechanic doing the striping. And I have photos here, and those mistakes were routinely corrected without, dispute. They were just fixed. So we even have one where a stripe was omitted, and it happened to give the owner of that space a little extra space. And some stripes were only 2 inches off, and everybody decided we wouldn't bother correcting it because the stripe itself is 4 inches. So it was a moot point. So all of those mistakes were corrected. Now, because Mr. Saperstein did not draw our attention to that, his particular space, nothing was done about it. But it doesn't mean that there's a statute of limitation on incorrect striping, in my opinion. So I don't know why the process stopped when it came to space number 246, and 248, 7 and 8. So it just seemed, I'm just puzzled as to why it's such a big deal now. And I think, it would be very easy to show the old stripe, with a little chemical treatment on a 1-inch square would reveal the original yellow stripe. But that's just me. I have photos if you'd like to see a couple of shots of repaints. May I? Just 3 quick.
It's interesting, new question of technology. And traditionally, we can't take anything that we don't take possession of. And so if you can show us from there, I think we'll look at them.
We have his testimony.
Yeah.
We just believe him.
Yep.
It's okay. And there are some where if there was a mark on the wall, that's correct, but then the stripe splayed out wildly and so on. But these were sort of like routinely like, oh, that's wrong, just redo it, and it wasn't a big fuss. But anyway.
Do you know how many mistakes on your time? Were you part of the committee that was responsible for that at the time, sir?
I'm sorry?
Were you part of the committee responsible for ensuring that the striping was correct?
Well, I was involved with the rules, for writing the garage rules for the association, and I was on the board, but I don't think I was on the board at this moment, when the restriping was done in 2005. So I would say, to answer your question, I just took a keen interest on walking around and watching the striping person, you know. So some owners put their own blue tape line, you know, on the wall, and others, you know, just thought it would be taken care of. So that, I mean, it's just a puzzle to me why there's a big deal, because it's on every other floor, it's correctly painted, repainted, and on this particular pair of units, it's off. It's just a bad restriping.
Thank you, Mr. Chiaffo. Okay. I think that's all of our speakers. Any other speakers on this case?
Madam Chair, I have a couple questions now as of Mr. Washington,
Mr. Washington, if you come forward.
representing the Condo Association. Can you affirm that witnesses' last testimony with respect to mistakes having been corrected with respect to striping after the 2005?
I can't confirm that, but I can confirm that it had nothing to do with the two spaces in question.
Yeah, but
I
you
would
don't know
imagine- I don't
whether
know. I
any
can't
other
say.
space, do you know if any of the association officers could inform you of that?
As Mr. Edelson left, because he's the one that indicated that he...
Right, Mr. Edelson testified, and that very careful steps were taken to make sure that the stripes were put in the right location.
Well, I heard that, and I read his affidavit. Now I'm concerned with testimony that and I can imagine it's true, that there were mistakes made in the striping that were subsequently corrected after 2005.
I've got no record of that. I would not argue that it never happened, but I think that the point was that if there were mistakes, they were corrected. If there were mistakes made in the restriping that was inaccurate, but here there was no such.
I hear you.
need.
And the archaeology, the building archaeology that the witness referred to in terms of, it would be feasible to go beneath some of that to determine whether the line is in the same space. Isn't that possible?
Oh, certainly, it's possible.
And number three, do you have some citation for your latches argument, you know, that he waited too long to complain?
I don't have a citation, but if you'd like one, we can certainly submit one. But I think that there are legions of cases that suggest that, the statute of limitations would be in play here, which is 3 years.
Correct, based on contract?
Because they have a contract relationship with the association. The argument's either going to be the association was negligent in failing to have it properly striped. That's a 2-year statute of limitations. Or their argument is that they breached their contract with the association by.
Of course, that would be
not
told
maintaining
if he
it
made a
properly.
complaint, and if he lodged a complaint, then the statute would toll. He
Right.
would have to.
Well, but my understanding is that he didn't lodge a complaint for 5 years.
He says he talked to somebody for the board. I think he said hundreds of times.
That the board disputes vehemently. And the testimony
They have no record of any writing having been received from
there's
him.
absolutely no record of any complaints being lodged with the board or management prior to 2010. And I will also note that there was no evidence presented that the stripe was in the wrong place other than Mr. Severson saying, I didn't like where it was. But he had no evidence to support that.
Mr. Edelson, he says the best of his, he's not, his affidavit doesn't say he observed the striping. He says, to the best of my knowledge, upon completion, the dimensions, he doesn't say that he observed it, but.
But he does say that the methodology that was used and how it was carefully done to mark it so they would be in the same place, and Ms. Severson and Ms. Polchowski both said it was in the same place.
Yeah, and he's gone for the evening.
He is, unfortunately. We could get him back if we have to. I've got his cell phone number if you need him.
Okay. That's it. Thank you.
Mr. Russell?
Any other questions?
Not at this time. I don't think. It's with the board.
I just have some observations. I think I might have a question. And I call the board's attention to page A7 of the approved site plan 4.1, approved by the county board, and included in this and signed off by the various appropriate parties, signed off, is on that page shows that when there are columns, it's very similar to this instance, that You can measure, you do measure and meet the ordinance, 7.5 width, 7.5 width, 15 feet total for 2 spaces to the middle of columns. So that is compliant, I would, that situation, regardless of whether you can park a car in it or not. You can park some kind of car in it, I suppose. And I would ask the zoning administrator to refresh our memory on, is this that I see on A7 that shows what you do with an 18-foot wide column spacing and a 17-foot wide column spacing, is this permitted as a matter of right, or is this something that is done in site plan approved projects only?
I would say you could do it either way.
Either way. I thought so too.
Called for a 7.5-foot compact space.
And we allowed the 6, and that's what's actually shown on here and approved as part of the 4.1. You know, in helping us determine whether.
Yeah, they had 40% of the spaces could be subcompact.
Right, up to 40% could be compact.
But that only, but the subcompact only helps us to get to the 7.5. Or, you know, the fact that it has to be complying. It doesn't allow for anything less than that.
And it isn't less than that.
From the center of each column.
It's 15 feet. It's 181 inches, which is 7.5 each. Actually, what did I get?
7.55 maybe.
Anyway, it complies. We had a drawing that showed this is 181 inches, and 180 is 15 feet. Also, I wonder.
But, look, Mr. Russell, let me ask you that. Even though that would comply in terms of the space between the columns, what about the feasibility of determining then the actual parking within that space? I mean,
I don't think that's, my position would be that's not relevant. You know, somebody might own a, 1980 deuce and a quarter. It's not fitting in practically any spaces that are built now. And so I don't think you can say that that a space has to accommodate a car.
But I mean, again, math is, so if we take this and we divide it as the administrator has articulated, aren't both spaces then non-conforming? Or you're saying they're not non-conforming because the site plan says it can be 15?
You're almost exactly. Is my point of trying to figure out a way to say that it's not.
Okay, I can find that part.
I mean, that was envisioned in 1999.
Well, it's standard. Yeah. It's done in buildings, other buildings too. It was the standard way. You're allowed to have a space, as I understand it, 7.5 feet wide or 9 feet wide. That standard condition of a site plan approval, and Ms. Cozart believes that is also permitted in the county for by right spaces, allows column projection of 6 inches into each of those spaces. And those measurements are all shown in the record that we have. So I mean, I'm having trouble getting to where I'd like to be in light of that. Then I think this that we got kind of complicates the issue. And do we have a request for a variance? Or is it just simply a denial of a granting of the appeal, which then just ends it?
There's a request for variance here. But in the options that I discussed with council about how you could remedy this, you could restripe it, or you could actually go for, in this case, a site plan amendment to maintain the status quo.
A site plan amendment before the county board.
So we wouldn't have jurisdiction to do a variance, you think? That's your determination? Because because you didn't encourage them to actually file for a variance, at least as far as I could tell. It's the verbal request. There's not a...
Right. This is a site plan project. And the site plan project is governed by the site plan conditions. And to me, if they wanted to maintain the parking spaces as is, they would need to apply to the county board for a site plan amendment to maintain a substandard parking space.
Well, but the question that Mr. Russell poses to us, Mr. Smith, is it in derogation of the original site plan if it's in conformance with the original site plan requirements? That, you know, that they can have it be measured in this other way? I mean,
And if I could just offer a point of order, when we filed our appeal, we did file a request for a variance.
but did you pay for a variance? Did you pay? I didn't see.
Written out like we usually
Yeah,
see it.
I was going to say, I didn't see the filing fees or the,
Right, it is different, it's like kind of incorporated in the.
I saw it.
It is. It's in the report.
Yeah.
I wasted time with that. Just go on. Well, that's good. At least we could grant a variance if it was
Right.
assumed that we could. Although I think the administrator, I think I'm hearing the administrator say that to vary a parking space in a site, 4.1 site plan building is under the purview of the county board. And if the county board has the ability to approve that, the Board of Zoning Appeals does not.
right?
This is as I understand, it's an appeal of a notice of violation.
Right.
Was the zoning administrator incorrect in issuing a notice of violation? And it's not that the spaces aren't right under the site plan as I see it, it's that the line that divides them is in it. And when I look at this condominium document, I wonder about where the property line really runs.
Right.
Regardless of where this line is, perhaps the property line based on the condo document, and that's out of our purview too.
But I guess my trouble with all of this is whether we have the right parties before us. I mean, is it the condo association the right person to be citing, which was one of the preliminary questions that were raised as the people who are being charged? I mean, that was to me the fundamental question. So, Ms. Kozar, could you speak to that as to why you cited the violation against the condo association?
Because when you have a condominium and it's in a garage, a common area, then the condo association has jurisdiction over that area.
Except, how does that fit with the statements of and the appeal by the Severinsons that they actually have a property right interest in the space that they purchased? And if you look at, and this isn't in the purview of the board, I agree with you, Mr. Russell, but if you look at the condo association document, the Severinsons' parking space seems to confer the space that it currently consists of.
Mm-hmm.
So then you get into a whole question of,
But the condo association manages the garage.
Yep.
So whatever happens in the garage or the common elements is under the purview of the condo association.
but they,
And the way I look at it, Madam Chair, is the line is not owned by Ms. Severson, it's owned by the condo association.
but what she purchased in her documents would be owned by her.
Between some lines. And if the line is in the wrong place, God bless her, she has clean hands, but the condo association owns that yellow thing, and it may be in the wrong place.
I guess.
The poles the columns aren't going anywhere. And they are what they are. In 1999, they said you can have, you're supposed to have X number of spaces, but we're going to give you some relief from that, but you can have 40%, up to 40% that are substandard, subcompact. And these are an example of those, and it was the condo association's job, and they did in 1999, and they were inspected in 1999 by the county, and they were issued a COA. In 2005, there was a restriping. We have testimony that there were errors made that were corrected, and maybe this is the case of an error that was made that was not corrected. But be that as it may, it's non-conforming with 1999, the site plan, and you've got a notice of violation. Was the issuance of the notice of violation correct? Seems to me. And that any kind of, I mean, it seems to me that any kind of conflict is really between the individual space owners and the association.
But I guess I'm struggling because I don't see fundamentally that we have jurisdiction. I'm not sure we have jurisdiction over the issue if this is a site plan and the remedy vests with, if any, rests with the county board, and if there is nothing in violation from the site plan that was approved and that spacing. I mean, to me, because as Mr. Russell has raised the issue, if the space is consistent with the site plan, the space being 248 and 247 together between those columns, being sufficient to legally convey the sufficient space that was required under the site plan. I don't know.
But I mean, it seems to me the administrator has issued a notice of violation saying that this is not conform with what was approved in 1999 via site plan, and that's why you're being noticed of violation of that. Is she?
Based on the stripe down the middle. It's not that the distance between the columns and so forth is not conforming. It is. Right. It's conforming for 2 spaces, and it's shown on this condominium document showing where the line apparently is supposed to fall or where the property line falls in having ownership of these spaces, showing them each, according to this, 7 feet 8 inches and 7 feet 6 inches. Both are over 7 feet 5 inches, and they're measuring from the middle of the columns as is permitted by the site plan. Under the zoning, it's irrelevant whether it's condominium owned or it's gang parking or anything else. It's the size of the space and the number of the spaces in the building that are part of the zoning approval that's before us. Where, you know,
I guess I'd like to ask Mr. Puvek if he has any comment that he would like to make with regard to the discussion that we're having, especially because your argument is that there's some independent property right, and I think the board is discussing that there would not be.
That doesn't touch us.
And I guess the more specific question is what your position is vis-a-vis the measurement running from the middle of both columns as to the space that was deeded to your client, because it seems to me that the argument is your client is entitled to the amount of space that she has, that there would not be any taking of that space if the property is divided down the middle between the 2 columns.
I guess I don't understand the question because, I mean, I think that's the present dimension of the space is consistent with what she purchased. So
I guess what we're saying is, though, consistent with the site plan, if you take that space and you divide it,
so it's not.
What's your argument that is still a taking if all she's entitled to under the site plan is a division of that space between the columns, as measured between the columns?
Well, to be clear, she's entitled to what is in the declaration, and that's what her deed references. Her deed references the declaration, and it's referenced in the exhibit that I gave you.
Okay,
so,
but
that is then based. That document was then based on the 4.1 site plan. So
the 4.1 site plan appears may be in conflict with what that document is. It may not be, because the 7.6 inches that she has can, if measured from the middle of the column, still exist, but it won't be as big as what's reflected in the current picture.
in the current deed, I mean, we're talking a matter of an inch. You're looking at the different. It's my understanding that would be the difference. I mean, if we take that as the size of the space.
Mm-hmm. No, but you're missing the point, because the size of the space would be measured from the center of the column, which will not make it the same space that she has.
Well, that is measured from the center of the column.
Yes.
Hmm? This picture is?
Yeah. Did you see the lines running through the middle?
I know, but I guess I'm trying to get clear in my head what we're taking if we sustain the zoning administrator's determination the line must be moved from Mr. Puvek's client.
May
Because he made the argument that somehow that would be an unconstitutional taking, and I'm just trying to figure out where that would be.
Well, I think to echo it, I think Mr. Washington made the argument again that the condo board would have to do that, and the condo board does not have the power to do that. Condo board does not have the power to take the size of Ms. Severson's space.
But I guess the fundamental question is, why is there any sense of taking if all the condo board is doing is remedying the striping between two spaces?
Because she has the right to the size of the space, which is consistent with what is in her deed, which is the present-day space.
Well, but, Madam Chair, the 96.5, you'd agree, is 8 feet, 8.5 feet, right?
Right.
And 4.1 says she gets 7 feet 6 inches, right?
I can't see the document that you're reading, but
Okay,
I don't believe it's
I'm sorry, the
4.1.
declaration. Doesn't the declaration say for space 247, 7 feet 6 inches? That's at page 74 we've been talking about.
Right. I mean, the documents speak for themselves. I don't think you need me to speak to
I mean, you agree that that's what it says, and it's speaking for itself and says 7 feet 6 inches. And this picture says she's got 8.5 feet. Correct?
Correct.
Okay. And would it have been her position that that she got a few extra inches in 1990? I don't know what year she bought it. 99? Was she said 15 years. So that would be what?
She was the original owner in 1999.
So she got too much at the beginning?
Again, I can't speak to that. I mean, the space of the space is in the declaration, and as it exists today, it hasn't been changed. I think you heard plenty of testimony from the condo board council that the size of the space has not changed.
Okay.
But isn't that irrelevant? I guess that's the issue. Thank you.
I mean, it goes to a kind of a different issue, but I think, well, my position would be that, you've got a site plan that says you're supposed to have X. You don't have X. And so the zoning administrator issued a notice of violation because you don't have X. If they had X, then she would be wrong. They don't have X. They've got something else, for whatever reason. And how that's solved, maybe it is solved by, I think it is solved by actually either site plan or they internally, come up with a solution. But I don't think that the zoning administrator is wrong in saying there's a violation of the site plan. Though I think it's been excellently argued, though, on the behalf of the association council. And I will say, in the interest of I'm not a member of this condo association, but I am a condo owner, not a board member, but I'm a condo owner for the last 10 years, too, so I understand how they work in general.
Does the board have any motion? I mean, are we ready to move to that, or are there any more questions or discussions?
The question is whether board members are ready to act, or if a deferral would be appropriate to another meeting to answer some questions regarding whatever the board might have questions about.
Madam Chair, there's a member of the audience with her hand up. I don't know that there was a speaker slip entered. Young lady on the left.
Unfortunately, it is, unless we defer it, and then, next month we can take your testimony. This is why I said speaker slip so many times.
I believe the rules actually say that once testimony begins, no more speakers can be taken. Not all jurisdictions do that, but this one does.
Well, except I haven't said it in my opening in recent months, so. But generally, that is the practice, and that's why we say what we do in terms of filing the speaker slips. teeing it up to the circuit court. I'm trying to see what the right issue is.
Well, I mean, under the code, the only question is, was the zoning administrator right?
Well, and I guess,
Correct, they use the word correct.
I guess, Ms. Kozar, let me ask you this question, because the one piece of evidence that I'm not fully comfortable with yet is and I think I know the answer, but the rules with regard to time limit on you bringing a violation. Are there any such rules? Just to put the record clear.
No, we respond to when somebody brings a complaint, and we investigate, and if we find that there is variation from what was approved in the site plan or a condition, or a variation from what is called for in the zoning ordinance, we file a violation. You could have a violation filed on a complaint corrected. Next year, the violation happens again, and we could violate the same thing every year in perpetuity if it goes in and out of compliance. So our violations are based on something not being compliant at that time. And it doesn't matter how long it's been going on as far as we are concerned, and as far as how we respond to a complaint.
And then the other issue I want on the record before we make a determination, if we do, is the question with regard to your position on notice to the Severinsons and why that was deemed unnecessary in this case.
There was no violation of space number 247.
Because
Party to this.
because their space can be either, their space was not too small,
Right,
and there's no such thing as too large because it
right,
could be up to 9 feet.
right,
Is that correct?
right.
So just want to get those facts on the record. That being said, any other questions for the zoning administrator or any parties? Final thoughts, are we ready to take any action? Even in the form of a deferral for this, no, not ready, but,
Well, Madam Chair, if I ask the appellant and the zoning administrator, how they feel about deferral.
I don't know to what end.
Okay, there are two members of the BZA not here, and
Well, I guess I don't want to repeat this. I think we have the record before us. I think we know, the issue is whether we are prepared to make a determination to, regarding the zoning administrator's issuance of the notice of violation and civil penalty. That is the question before us. If we are ready to rule on that question, the answer, under the ruling, we simply need to answer, we affirm the zoning administrator's determination, or we do not affirm the zoning administrator's determination. I believe, for the record, that's all that we can do. So each board member will be asked in turn. Mr. Russell. Let's actually start with V10807-13 APP1, which is the initial notice of violation.
Aye.
Mr. Smith votes.
Mr. Smith, sorry.
Votes yes.
And Ms. Espinoza, the chair, also votes yes to affirm the zoning administrator's determination. And now, with regard to case V-10807-13 APP1, is that the same number?
No.
Regarding parking space 247, where the applicants are Lucky and Karen Severson. Mr. Russell.
Yes.
Mr. Smith.
Yes.
And Ms. Espinoza. Votes yes. So both appeals are found not to be sustained. Your next action would be to go to the circuit court, or as the zoning administrator has indicated, potentially to the county board, as this would be an amendment that would need to go through site plan amendment.